Next up is, we'd like Ben Rasmussen to come up. We're going to talk about the R277 404 hearing. And you coming up here too, right? Okay.
Okay, thank you, Mr. Chair. As board members will recall, we had a public hearing on R277 404 following our November board meeting, your November board meeting. And so this is before the board today. We've assembled the hearing record, which is available for you to review on board docs, which contains the public comments submitted. And this is before you for discussion today.
Before we go to a discussion, I'm seeking a motion to accept the R277 404 hearing record.
So moved.
Okay, do we have a second? Have a motion and a second. Discussion, Vice Chair Ellis.
I would just like to see that we respond when we have hearings. I talked to Deputy Superintendent Angie Stallings earlier because I remember there being a discussion when I was on Law and Licensing Committee about, but we failed to remember exactly where it was, but when we have a hearing, just doing some sort of response back instead of leaving everyone hanging when we have hearings. And I thought we came up with something, but because the law says that we shall consider, but it just seems, anyway, so I just wanted to put that out there for people to consider, looking at a way that when we have hearing requests, that we don't just listen to them, but we also say thank you or something instead of, I don't know. Being on the other end of it, it's just kind of frustrating to come and just feel like you're talking at people and then never getting any type of response. So I don't have a recommendation. I just want people to think about moving
Okay.
forward with some sort of protocol for whatever we have, that there's some sort of communication back to the requesters after the hearing.
Angie, just so you know, when people request a public hearing, just to brief, could you brief the board quickly on, there's a request, how does that work? They create this opportunity, there's limitations within that opportunity, and I guess my follow-up question is, do we fulfill all the requirements for this public hearing? So, here, let me turn this back.
Yeah.
There you go.
Thank you, Chair. Angie Stallings, Deputy Superintendent of Policy. The statute and the regulations regarding your rulemaking authority and then the process of what happens when you get a request for a public hearing is to assemble the hearing record, which Ben has done on your behalf, and then all of that information, including the public comment, is meant to be a tool for you to use and consider to determine if you want to make amendments to the rule. So I would state that the ultimate response to people when they request a public hearing is to see the action of the board on that rule as a result of the public hearing. So the response would be, if you make no amendments, that although you considered all of the comment, that you decided to stick with the draft version that you filed with the Office of Administrative Rules, or it could be that based on this hearing record, you determine that you want to make amendments to Rule 404. So that has usually been the course, is that once we receive the hearing record, it's your opportunity, and that's kind of the next agenda item, is to potentially take action on the rule based on the hearing record, which includes all of the public comment. But I'd be happy, Board Member Ellis or others, if you would like there to be something in addition. But I think at the end of the day, what they're trying to influence is the rule, the language of the rule. And so that would be the opportunity for you to make amendments or change it.
Okay. Sure, but okay.
Sorry. I understand, thank you. I just meant all the steps that you said, if we just put, and I'm not talking about this specific hearing, but in general, put in a protocol so that whatever happens, we respond back. The report was received, someone made a motion to do there, or the report was received, no further action was taken. Just some sort of closing the loop.
That makes sense.
That's all. I'm not trying to push anything specific, just.
Okay, we have a couple other board comments. The motion that's on the table now is that that we accept the R277-404 hearing record. Comments to that motion, Board Member Lear?
Never mind, it's not germane to the motion.
Okay. Board Member Cannon?
Well, I just want to add a bit to the conversation and say that as a result of that public hearing, it seemed to me that there were several members of the public who brought up questions of the legality of what we were doing, or saying that we were violating code and so on and so forth. At which point I asked our AG, Brian Krisenberry, if he would take a look at it. And to that end, he did, and sent us a great memo. And as I read through the memo, it seemed to me like the allegations were not held up, that we were okay within the law following what we have stated in 404. So I appreciated that look very much. Thank you, Brian.
Okay. Any further discussion to the motion? Oh, Board Member Lear.
To Janet's point, I would like that memo to be available to the public, because I'm assuming it's now specific to the board, and I would like it available to the public for the public to understand the legal advice that the board received.
Okay, our AAG, Brian, quickly responded, so I didn't have to, so that's what, Brian.
Sure. I don't have a problem with that. Let me remove the confidential label that's on that, and then I'll pass it over to Lorraine, and she can pass it on. Sure. Sure.
Okay, but before we do that, I think that before we say yes to all of that, I'm not sure if this is the right way to do it, but I think it is. When we have a memo or we get communication from our AAGs, it should take a board. If we're going to make them public, we should get a motion.
Right.
And would that motion be out of order because it's not in here to release?
Yeah, we've got a motion on the table right now.
I know, but I'm just saying for later. So I'm just managing everyone's expectations, so.
The board's in consensus, it doesn't need to be. a
Okay,
motion.
all right. It shouldn't,
It's not on the agenda, so.
okay, it's not on the agenda, but I'm gonna see if there's any objection without it being a motion. We just have to be kind of careful when we make those requests of our AAG, and then bam, shoot them out there, client privilege thing. Okay, the motion before the board is that we approve, or motion is to accept the R277-404 hearing record. Any further discussion? Seeing none, let's vote. All in favor say aye. Aye. Those opposed?
It's Tara.
Okay.
Is it Tara or is it Jenny?
Is that
Didn't catch that.
Oh, it is Tara.
Carol, welcome.
I've been on.
Yeah,
Can you hear me now?
yes.
Okay. I'm just trying to keep the static down.
Okay, the motion passes unanimously. Without objections, we will prepare that memo release to go out to the public. Okay, I'm not seeing any. Okay. Okay, you guys need to stay up with me if you can. I'm not going too fast, but we're back to the memo that Brian prepared for us.
Well, you said seeing none, so I thought that you were talking about the next item.
No, okay. Okay, so we're gonna prepare that memo. Okay, so that's, I was just getting, it's without objection, I'll release that memo. We'll have that,
Just the hearing, or are you talking about the legal report? Because I did want to talk about
The legal report.
well, the legal report's not on the agenda, it's just, it went, yeah, but we're gonna take a disclaimer off. Well, if you're gonna, I guess when we're looking for any other motions or anything that has to do with the R277-404, so that's what's on here, so everything that's related to that still game. Okay,
Or can we say out loud, whoever has their phone on, you didn't speak. Mrs. Terrell?
She can't hear you. Mark has to tell her on the mic.
Okay, can you guys, that's on your phones, mute?
Maybe she can't hear you.
Hey, welcome to my world at times.
I have it muted.
Okay, thank you. Okay, this concludes the hearing record piece, and now if there's any proposed actions from this, and I'm going to start off with Vice Chair Ellis.
Thank you. I move that we move forward the October draft of R277-404 to be put in place with the technical changes that were made, and then send the rule back to committee for discussion.
Is it
So-
one of these options, what you just said?
Which one would it be, Angie?
So we,
It's,
Is it draft one?
yes, October draft one.
October draft one
that you approve, your motion was to approve.
on
to
second
approve
and final reading.
R277-404, October draft one on second and final reading, and
Move the rule back to committee for
And-
consideration. And
and
then I'd
send
like
the
to speak
rule
to why.
to committee. We have a motion, do we have a second?
Second.
Second, do you want to speak to the motion?
Yes, please. So I'd like to put the rule in place because there were technical changes, dates that needed to be altered, the name of the test that needed to be updated, so technical changes. But also in the spirit of the hearing report, I'd like to discuss some of the items brought before the board, but also there are some questions that I've had raised about the testing ethics manual that is in place, and also CTE course requirements being put on the list of tests that are opt-outable, and I think that that needs to be a committee discussion because they can't get a certificate if they opt out for those CTE courses. So those are just a couple of the reasons why, aside from the hearing, which is a bigger discussion, why the rule needs to go back to committee.
And you wanted to go back to committee for further
For
discussion?
further discussion and amendments, well, possible amendments. I
Okay,
guess.
so, well, if it goes to discussion, then it goes from there, so, are you, okay. We have a motion and a second, we're speaking, and the motion is to approve R277-404 October draft one on second and final reading and send it back to committee for further discussion. Speaking to that motion, Board Member Cannon?
I'd like to move that we divide the motion and vote on the first part, whether or not to approve R277-404, and the second part as sending it back to committee.
So it's a motion to divide. We have a second. There's a ton of lights on. Are you speaking to the motion to divide? If you are, your light is on, correct? Board Member Hanson?
No, I'm,
Okay. Board Member Belknap, this is on to divide. Board Member Lear, are you speaking to divide? No, I'm not speaking. Okay. I'm not seeing any other. Yeah, it was nice. That was great. Okay, so the motion is, before the board is to divide. All in favor say aye. Those
Aye.
opposed?
Aye.
Any opposed? Okay, seeing none, we're dividing it. So the motion before the board, the first part, is to approve R277-404 October Draft 1 on second and final reading. Not seeing any discussion to the motion, so let's vote. I'll restate the motion before we vote. That is to approve R277-404 October Draft 1 on second and final reading. All in favor say aye. Aye.
Aye.
Those opposed? Motion is unanimous. The second part of this is to send it back, send R277-404, October draft one on, well, the one we just passed, so am I saying it right? What's that? Just R277-404 back to committee for further discussion. Discussion to that, Vice Chair Ellis?
I'm only stating this publicly, so anyone in the public sphere that freaks out if this doesn't pass, any board member that requests an item, and the two board members that request an item can have an item brought back to committee. So whether this passes or fails, I plan on bringing this rule back to committee.
And I usually don't weigh in on very much, but this needs to come back because of the CTE. There's a huge rhubarb, let's see, I've got to get this in the right context. There's some significant challenges with some of our CTE certifications with the way this is, and so we kind of need to get it kind of handled or have a discussion on it. So I'm okay. Not seeing any other discussion on having it. The motion is to take R277-404 and send back to committee for further discussion. Okay, let's vote on it. All in favor say aye. Those opposed?
No,
Okay, with the ayes, raise their hand.
my hand is raised.
Is that Carol?
Carol. Okay, Board Member Wright, Board Member Belknap. So there's 2, 3, 4. Board Member Stokes, Board Member Nielsen, Board Member Bolter, Vice Chair Ellis, Vice Chair Brittany Cummins, Mark Huntsman. And you're an aye? Okay.
That's mine.
Okay, motion passes.
Probably should know all the no's, though. just
Who are the noes?
So I get those on the.
Okay, I'm calling out the noes on that past vote. So we have Board Member Hanson, Board Member Reby, Board Member Lear, Board Member Cannon,
And what's Jenny?
Board Member Gravitt?
Board Member Gravitt.
Clavier, yes.
It passed.
Because it's all part and we have our people here. So there's another question or comment regarding the hearing record and/or the communication that we received from our AAG. So, Board Member Ellis.
Thank you. I agree that the memo needs to be put out in the public. My only concern is that, and so my question is, as attorneys, when you put out a legal opinion, would you say that it is, that there's no other interpretation, or that someone else could come up with a different interpretation of compliance or the law? That's my question, because I'm just concerned about putting something out there and it's just kind of like, done, end of discussion, when someone else that's an attorney may look at it and come up with a different opinion or finding. Am I correct, or do you think that there's no?
Okay. This
There
is
are
a
attorneys,
question,
but
Board Member Lear, this is a question for our AAGs.
Before you even said that, Mark,
Okay.
I undid my life.
Okay, I didn't, your light was up first. I wanted to recognize that, so, but I knew you wanted to answer it really bad.
I wouldn't presume that my opinion is the sole and universal opinion on. However, I would say my opinion is educated and reviewed and
Right.
thorough. So, but can
But if
another attorney disagree with me?
well, like if we got the legislative attorneys who, like, you know, the intent of the legislature when they put this in place, could one of them look at it and possibly come up with a different finding?
Who's to say?
Right. Well, that's just my only concern. I just get concerned that we put things out there and it's like,
Okay.
mum's the word, and I don't know that that's
And
true.
this has been a really good question, and other board members in the past that said, a legal opinion is just that. It's a legal opinion. And one thing that's really nice about having Michelle on board and that a lot of these opinions are going to be too deep. And if there's a conflict, then we have access to other AAGs that can kind of help on this. So these are just legal opinions. They're not a judge on all of this, and so that's what it's weighed out. So I hope that answers. Board Member Lear.
Okay, now I feel like I can weigh in on it because Elisa did. It may be that any other attorney can speak to the issue, but these two attorneys speak for the board. And so it's the board's attorneys' opinions. And I think that, no, absolutely. But I think it has some weight, as I've been reminded many, many times, because it is the board's attorney's opinion. So I think that, yes, 15 other people 300 other attorneys can have opinions. But I think putting it out there as the attorneys general who speak for the board is an important point. And legislative attorneys don't speak for the board.
That's why I just want to throw this out also, that when we get opinions, and that is for us, not really the public, but for us to help us as board members. You got to remember who they work for. They work for this board. And then, of course, other people in USB can ask for their opinion, but they are there to advise us as best that they can to help us make informed decisions. Do I have that wrong?
No, you're right.
Okay, so with that in context, they're not speaking for the legislature or anyone else, but it's still an opinion. Board Member Hanson, did you have a comment regarding any of this?
I just wanted to say that the value is in the fact that we used that memo to make a decision, and so, as a board. And so I think that's the value in letting the public see it. So now they know that's what we used to help inform the decision.
Okay, Board Member Belknap, and then,
My opinion may be a little different than others, but I don't believe that every time our AGs give us an opinion that we need to put it out in the public. We should use it in-house for ourselves to make our own decisions, and I would prefer that we don't open that door up and start throwing these opinions that were given to us out on the table.
okay. Vice Chair Ellis.
That's a good point, Laura. I agree with it. I think the reason why is that people are suggesting it is because Board Member Cannon asked them to respond to some inquiries of the public, and so that's why I think that's out on the table for people to do. And I understand it's just an illegal opinion. I know that the legislative attorneys aren't. I was just trying to put out there that there are differences, and I appreciate our attorneys and their legal advice, but I don't think that means that we always have to agree with the opinions that come out. That's all I'm trying to say.
Let me go to Board Member Reby that was anxious to. Did you have your light on?
I do. As we banter this back and forth, we have districts out there that are trying to make decisions about what they're going to do this year. So we should really be cognizant of the fact that we should have times when they should start and when they should be expected to put these into place. So as we go back and forth over and over again, we really are leaving our districts, who we're supposed to be serving and helping, in the lurch.
Okay. Board Member Lear, okay, before you do that, AAG Thomas, do you have another comment? Board Member Lear, your light's still on. Oh, Brian.
Just 2 points. One is I think releasing this memo is more the exception to the rule, and the rule would be to keep it confidential, or memos in general confidential. Second point, and this was unique as well because we did have public that specifically requested in the committee or claimed that there were some illegalities with this memo. So I think that made this somewhat of an exception. The second point is, in our memos, we tried not just say here's the law, but include analysis and try and persuade the readers of the memo to the conclusions in the memo. And so if you want to question the memo or the analysis, certainly talk with us and we can work through that. So, but my goal is just to persuade you to my conclusion.
Okay. Board Member Lear.
Well, I hope in response to that, your goal is not necessarily to persuade us, but to provide your analysis so that our thinking can evolve the way yours did, which is maybe a slight distinct difference. But I also want to say, I normally, or I agree with Laura to some extent, but I think because this hearing raised so many legal issues, I think it's important to respond with a legal analysis so that our thinking is explained. And I think we should approve the release of these on a case-by-case basis, not, and I don't think there's any precedent setting in releasing some and not others. I think there's different reasons for doing it that are readily explained.
Okay, and that's why we spent this extra time on it, because people put us in here, we go get our own we don't owe justification to the public on, we don't have a venue or an opportunity to justify every one of our decisions with backup from our AAGs, but this, and I'm supportive of this going out because of those public requests and that, but, so we'll just proceed as normal here, I guess. All right, moving on. Board, I see a hand, but I don't see a light. There we go. Board Member Belknap.
I would like to reconsider sending this out, and more than anything, because I want to vote no to putting it out. So I'd like to have a vote on this. I'd make a motion that we do not send out this memo.
Okay, wait. So if I'm not feeling like we have a consensus here, that's the only way it's going out, because the chair is saying it's going out because I believe there's a consensus, because this wasn't a vote. If there's not a consensus,
There's not a consensus.
and I'm seeing quite a few heads.
So what,
So what
tell
will
me how to
happen,
proceed then.
what will happen in order for this to go out is it's got to be on the agenda. A couple board members make the request, and it shows up on an agenda in the future.
Thank you, Chair.
So it's, with that, because and I'm all within Robert's rules and everything else. So it's on a hold mode, and if somebody wants to put it on the agenda, then we'll bring it out and speak on it. Okay. We have more business to take care of. Okay, we're moving off the hearing report. Thank you very much.